Welcome back to another explainer. So, picture this. You're sitting at a closing table, ready to finalize the purchase of a property. In front of you is just this seemingly endless, overwhelming stack of dense legal paperwork. You're signing page after page after page. But buried within that mountain of documents lies one single, absolutely crucial piece of paper that powers the entire transaction. It's called the promissory note. Today, we're going to isolate and totally demystify this document because understanding it is the absolute foundation for understanding how mortgages, foreclosures, and loan servicing actually work in the real world.
We really have to start with kind of a provocative question. What actually happens behind the scenes if you stop paying your mortgage? I mean, it's easy to think, well, the bank just comes and takes the house, right? But legally speaking, the process is far more specific and intricate than that. How does one simple missed payment legally trigger a massive event like a foreclosure? Well, the answer lies entirely in the mechanics of the promissory note.
Okay, let's establish a rock-solid foundation here. The Consumer Financial Protection Bureau defines the promissory note as the legal document signed to agree to repay a mortgage. It lays out exactly how much is owed, the interest rate, the repayment timeline, and most importantly, the specific consequences of failing to make those payments. So this isn't just a receipt, it's literally the core engine of your debt.
Here's our roadmap for today. We're covering 1. The promise to pay, 2. Note versus deed versus mortgage, 3. Anatomy of a note, 4. Default and acceleration, 5. Transfers and enforcement, and 6. Busting mortgage myths. Let's get into it.
Section 1. The promise to pay.
This right here is the absolute core reality of the document. I want you to continually return to this core mantra as we go through the rest of this explainer. The note is the borrower's written promise to pay. It's the debt instrument itself. It tells us who borrowed the money, who they promised to pay it back to, and the rules for doing so. If you ever get lost when the legal terminology gets a bit dense later on, just ground yourself back in this one simple fact. The note is just the written promise to pay money. That's it.
Section 2. Note versus deed versus mortgage. So we really need to separate the note from its frequently confused siblings, because honestly, most foreclosure confusion begins right here. A deed and a note serve completely different functions. The deed is all about title. It answers the question, who owns the property? The note, on the other hand, is all about debt. It answers the question, who promised to pay? A person can actually hold title to a house via a deed, but still owe money under a note. Bad legal arguments constantly start when people mistakenly collapse the deed and the note into the exact same thing. They are entirely separate.
And here is how the note differs from the mortgage or the deed of trust. Think of the note as the engine of a car and the mortgage as the chassis. The note says, I promise to repay this money. The mortgage is just the security instrument that says this property secures that promise. Without the engine of debt, the note, the collateral doesn't go anywhere. You just cannot analyze a foreclosure by reading only the note. And you can't analyze the payment obligation by reading only the mortgage. They're a pair, they work together.
Section 3. Anatomy of a note. Let's deconstruct the specific parts of the note itself. Breaking down the exact parties and terms really clears up who owes what to whom. A note usually has a maker, that's the borrower who signs and promises to pay, and a payee, which is the original lender to whom the money is owed. Now, here's a really interesting detail. Sometimes a person might sign the mortgage to grant a security interest in the property, but they don't actually sign the note, which means they aren't personally liable for the debt. So identifying exactly who signed what is absolutely critical.
Inside the document, you're going to find some very specific mechanics. You've got the principal amount, which is the money borrowed. It outlines whether the interest rate is fixed or adjustable. The maturity date tells you when the loan has to be fully paid off. It also clearly defines the prepayment rules, what exactly constitutes a default, and those powerful acceleration clauses. These elements dictate exactly how the loan functions day in and day out.
Section 4. Default and acceleration. So what happens when that fundamental promise to pay is broken? First, we have to understand that the word default isn't just a casual slogan or some warning from the bank. It is a very specific contractual and legal condition that has to be proven if enforcement is ever challenged. Usually, yeah, it means missed payments, but it can actually involve more than that depending on the exact text of your specific note and security instrument.
Let's walk through this step by step to show how a simple mispayment snowballs. First, a payment is missed. Second, the legal condition of default is reached, based on how the note defines it. Third, and pay attention here because this is maybe the most important concept in the whole document, is acceleration.
Acceleration means the creditor invokes their right to declare the entire unpaid balance immediately due. Without acceleration, you really only owe the missed payments, but with it, the full loan balance is demanded right now. And finally, that accelerated debt is what triggers Step 4, foreclosure via the security instrument.
Section 5. Transfers and Enforcement.
Now, notes don't always stay with the original lender. Let's trace the physical life of the paper itself. After origination, a note might be transferred using an endorsement. That's a signature or a stamp right on the note itself. Now, if there isn't enough room on the original piece of paper, they use something called an allonge. It's just a separate attached piece of paper specifically used for endorsements. A lot of legal disputes actually center entirely around whether these endorsements or allonges are valid, properly attached, or authorized.
And that brings us to the Uniform Commercial Code, or UCC, specifically Article 3, which governs these kinds of negotiable instruments. Our sources emphasize a really strict distinction here. The person who owns the economic interest in the loan is not always the person legally entitled to enforce the note. The holder is generally the person physically holding the endorsed paper. The person entitled to enforce is the party with the actual legal rights under the UCC. This is a big deal because just because a servicer collects your monthly payments, it doesn't automatically mean they own the loan. They might just be authorized to collect on behalf of whoever is actually entitled to enforce it.
Section 6. Busting mortgage myths.
Because this legal paperwork is incredibly complex, a ton of internet theories have popped up over the years. Let's objectively test a really common one you've probably seen floating around online. The myth goes like this. If I demand to see the original wet ink note and the bank can't immediately produce it, my debt legally disappears. Well, let's look at the reality.
The answer is a definitive no. Our sources make it crystal clear that while original note issues absolutely can matter in litigation, a debt does not automatically vanish into thin air just because an informal demand is made. Courts systematically analyze note enforcement under state law, rules of evidence, and they have very specific lost note affidavits and procedures. The debt still legally exists, it just has to be navigated through proper court procedures.
Okay, here's another persistent one. The myth suggests that a borrower can magically discharge their promissory note by sending the lender something like a private bill of exchange or a document stamped with A for V or accepted for value. Have you heard of this?
Again, checking this against the actual facts, the answer is no. According to our sources, these mythological documents, fake instruments, and private paperwork hold absolutely no legal weight. They simply do not lawfully pay a mortgage note. The only things that satisfy the debt are the actual payment of money or a legally recognized satisfaction of the loan. Period.
To bring all of this together, our source material leaves us with this brilliant summary quote. The note is the borrower's promise to pay. Start there, but do not stop there. The promissory note is undeniably essential, right? It's the engine. But it is only one piece of the much larger loan file, working right alongside the mortgage, the deeds, the servicing records, and state laws. You always have to view it in its full context.
We've covered a lot of ground today, from that basic promise to pay all the way to UCC endorsements and busting some internet myths. But I want to leave you with a final, slightly provocative thought. If the promissory note is the foundational promise of your debt, do you know exactly who currently holds the legal right to enforce yours? It might just be worth taking a fresh, informed look at your own documents. Thanks for joining me on this explainer, and we'll see you next time.